I welcome the opportunity to appear before this commission. We supported the passage of the resolution establishing it. It's unquestionably worth having a thorough examination of the costs in terms of health, safety, privacy, and many other things that we think are inflicted by the prostitution laws in this state, including their impact on marginalized individuals. Before I go into my presentation, I was asked to give a history of the prostitution law, what it means, where it is going. I want to make just three quick preliminary points. First, as I already mentioned, the ACLU has long opposed criminalizing consensual sexual activity among consenting adults. So while I hope to present a largely fact-based presentation today, I think you all ought to be aware that those facts are being viewed by us through this lens of supporting decriminalization. And there are at least three major reasons that the ACLU has had this position for so many years. One is the clear discriminatory impact that these laws have had on women in terms of their enforcement. What we consider to be a very broad invasion of personal privacy when we're talking about consensual sexual activity in private, and concerns about the enforcement techniques that have to be used precisely because it is a consensual private activity, and therefore it requires police to engage in various types of conduct that we think are inappropriate in order to catch people for engaging in consensual activity. Second, my focus is on Rhode Island, not on the national picture. I would note that 2 years ago, the National ACLU did issue a very thorough, detailed research report entitled, "Is Sex Work Decriminalization the Answer? What the Research Tells Us?" And it reviewed over 80 empirical studies that had been done analyzing the issues of the impacts of both criminalization and decriminalization of prostitution. And I would be very happy to share that report with members of the commission if you're interested in looking at it. I will just very briefly read the summary of the report so you have that. The summary, the report concludes, the research points to negative impacts of criminalization on the physical safety, health, and financial well-being of sex workers, with repercussions for clients seeking consensual sex between adults. These findings are only amplified when specifically examining the impact of the criminalization of sex work on marginalized communities, including LGBTQ people, people of color, and immigrants. People without adequate financial resources, such as those living in poverty, are also more harmed by the criminalization of sex work. Overall, the evidence suggests that going from less to more prohibitive laws on adult consensual sex work is damaging to sex workers and appears to have little impact on curbing trafficking or other crimes. Conversely, as laws move down the continuum from more to less prohibitive or restrictive consensual sex work, workers experience less harm, and there is no strong evidence to indicate negative impacts on crime, health, or safety. I would note that a number of the studies that are in that report do reflect analysis of what happened in Rhode Island between 1980 and 2009. When the so-called loophole, quote unquote, existed in the state. And it found, I'm no expert on this, but it did, there were some really major findings in terms of the decrease in STDs, in sexual assault, and those are certainly worth looking at. But again, I claim no expertise on those particular issues. The third and final point I want to make before I get into the bulk of my presentation is just comments about terminology. I'll often be using the term prostitution instead of sex work, simply because that is what the laws refer to, that is what the court cases refer to. I will more often not be referring to women, not because obviously it affects only women, but because they have and continue to bear the brunt of the enforcement of prostitution laws. And then third, I will be quoting some brief excerpts from court opinions. And I just want you to know I made some little tweaks. I got rid of citations to statutes. I didn't change the substance in any way, but I just wanted you to let it know in advance that they may not be verbatim quotes. So there may be a word or two that I've connected and so forth. So getting right into it, I think any Any discussion of the history of prostitution laws in Rhode Island has to start with the case of Coyote versus Roberts, which was a lawsuit filed in 1976 by the national organization Coyote, as well as the state organization at the time, and it challenged the constitutionality of the state's prostitution law as it existed at that time. That statute made it a felony not only to engage in prostitution, but also to engage in any other lewd or indecent act. There were Rhode Island Supreme Court decisions looking at another statute that interpreted lewd or indecent act to mean something as broad as one could ever imagine it to mean. The Rhode Island Supreme Court interpreted it to encompass all extramarital sexual intercourse, as well as any quote-unquote unnatural form of copulation, regardless of marital status. It could not have been broader, but it was on the books. The Rhode Island Supreme Court had upheld its constitutionality in a number of court decisions, and that was also its interpretation for the prostitution law, which banned just not only prostitution, but lewd or indecent acts. The state statute that was challenged made it clear, and I'll just summarize the court's explanation of what the statute covered at the time. The court said criminal sanctions could be imposed without regard to whether the sexual activity was a commercial venture undertaken for financial gain, or whether the activity was undertaken in private with the full consent of two adult parties. The statute also banned what the court called preliminary or preparatory activities for prostitution. Again, these were all felonies, such as loitering to solicit, transporting, aiding or abetting a person to commit an indecent act, and similar things. Again, these acts were all felonies without regard to the public nature of the activity, the mutuality of consent, or the financial motivation of the participants. The challenge filed by Coyote was on two major constitutional grounds. One, that the act was overbroad and impermissibly infringed on constitutionally protected rights of privacy and association. Importantly, they did not challenge the public aspects of the ban. That is, they did not challenge loitering to solicit or other public prostitution offenses. Instead, they focused on this constitutional protection of privacy, that the act, solicitation for the act, as long as it occurred in private, was no business of the government. The second major aspect of the challenge was an equal protection of the laws challenge. They argued that the statute was discriminatorily enforced, in that even though the statute on its face was gender neutral, women were almost exclusively arrested for violating it. And the court case presented a lot of evidence to that effect, and I just want to briefly go over a few of the facts that were presented to the court. First, the court noted that the police officer in Providence who was in charge of the prostitution arrest testified that from 1959 through 1975, right before the lawsuit was filed, prosecution for violation of the prostitution statute was primarily focused at females. Though males were arrested, they were not prosecuted, but were rather used as witnesses to prove the crime against the female. That was a testimony of the Providence Police Department itself. And then there were some statistics presented before the court, and I'll cite a few of those. Between 1974 and 1977, 846 women were arrested and charged with prostitution. In the same period, 251 males were arrested, but the police were only able to provide evidence that 3 of those males were actually charged with the crime. The police department also acknowledged that it used a total of 55 male undercover officers for prostitution investigations during the 1974-77 period, while employing no female undercover officers at all in 1974 and 1975, and 4 female officers in 1976 and 1977. And it was only with the filing of the lawsuit that the police department changed its practices in that regard. So fast forward a few years, discovery is being taken, depositions are being taken, the case is still before the court, And while the court was preparing its decision, the General Assembly amended the law. And this is 1980. And it did so for two reasons. First was the obvious one. There was this lawsuit hanging over the state's head, challenging the constitutionality of it. In addition, there was a large public outcry on the west end of Providence at the time, where there was apparently some very overt street walking taking place, hard to miss, out in public, and it generated a great deal of consternation in the community. It prompted public officials and politicians to get involved in trying to deal with it. And the solution they came up with was to streamline the legislation in a few ways.
Mr. Brown, I would like to offer you the opportunity, if you are comfortable, if you like, to remove your mask. I don't want you to feel rushed, and I don't want to make you feel stifled with it on while you're speaking to us. So if you're comfortable,
Okay.
You're more than welcome to remove it and speak.
I appreciate it. Are people having trouble hearing me?
No.
I'll go on this way for a little bit, and then I may take it off after my mouth starts getting very dry. Thank you. So as I was saying, public officials concluded that what they needed to do was streamline the law in a few ways. And the first one was to not make it a felony. That required a lot of legwork, casework in Superior Court. So instead they decided to make the crime a petty misdemeanor, which would allow for speedier convictions, not necessitate the right for a jury trial, and also limit the appeals that individuals could bring. They got rid of they changed the crime of, they added the phrase for pecuniary gain into the statute to specifically have it address commercial sexual activity. And they deleted the prohibition against committing the act of prostitution itself or any other indecent act. As a result of those changes in the law, as well as a change in Providence's enforcement of the law, all the parties agreed to dismiss the suit as moot in 1980. Now, I want to quote a few sentences from the court decision in which it was acknowledging dismissal of the case, because we have always pushed back on this notion that there was a loophole in the law that nobody knew about, it was unintentional, and it needed to be addressed. So here are some quotes from the court decision in 1980, a published court decision. The court looking at the new statute that the General Assembly had just enacted said, "The statute is now directed at suppressing specifically that type of sexual activity commonly regarded as prostitution. More significant for present purposes, the amendments appear to have decriminalized the sexual act itself, even when undertaken for remuneration. Thus, it appears to the court that the statute now outlaws only certain preliminary or preparatory activities, and then only when pecuniary gain is somehow involved. The core of plaintiff's claim was that the state could not constitutionally bar consenting adults from engaging in purely private sexual activity, irrespective of whether the motivation of one of the participants was economic. As the court reads these new statutes, they do not purport to outlaw that activity." So I don't think it could have been clearer at the time what the General Assembly had done, what the impact of it was. It was there in black and white in the federal court decision. Fast forward 18 years, in 1998, the Rhode Island Supreme Court issues a decision that essentially affirms this clear reading of the statute that the federal court had made in 1980. This case involved a person who lured women into posing as models for him and sought to videotape them and have sex with them with the alleged goal of creating pornographic movies. This person was charged with a number of violations of the law, but including a violation of the soliciting for prostitution law. And the Rhode Island Supreme Court said, "We believe that the legislature enacted this statute primarily to bar prostitutes from hawking their wares in public, whether this is done by strutting up and down a public street or by calling out to passersby from the shadowed stoop of a privately owned building. Because the statute is directed at the public solicitation of prostitution, its reach simply does not extend to this activity when it occurs within the confines of private residences. Although other sections of the Penal Code prescribe the defendant's challenge conduct, this statute does not. So this is 1998, so we're 18 years forward without this statute being able to be used to address truly private, consensual sexual activity. And Rhode Island had not gone the way of Rome. Nobody seemed to care or feel there was a problem with the lack of a broader statute. Then finally in 2003, after there was a lot of publicity about an attorney getting a number of prostitution charges dismissed on the grounds that there was no basis for them under the 1980 statute because the conduct had not occurred in public. It was purely private and purely consensual. Those charges were dismissed, and then at about the same time, the city of Providence began examining the rise of the so-called Asian spas in the city and began conducting raids on those spas. The rationale for them at the time was that sex trafficking was occurring in these spas, and some, if not all, of the people engaged in prostitution at these spas were the victims of sex trafficking. And that was generally what they hung their hat on throughout what became 5 years of a legislative battle here in the General Assembly to reinstate the criminalization of indoor prostitution. Now, one thing that we pointed out at the time when Providence first introduced the bill in 2005 was that there was nothing that prevented them from going after sex traffickers. While it was true, indoor prostitution itself had been decriminalized, there were a handful of laws that remained on the books that were felonies that would apply to individuals who were engaged in trafficking. There were laws against pandering, There were laws against pandering, harboring, and deriving support or maintenance from prostitution, all felonies that remained on the books, notwithstanding the changes in the 1980 law, and all of which could have been used to prosecute individuals who were in fact engaged in trafficking. So we had argued from the beginning that is not a legitimate rationale for reinstating this current allowance of indoor private activity. It's also worth noting that at the time, there wasn't a problem of police arresting people for prostitution. We looked at the statistics, and if you look at the Department of Corrections ACI population in 2008, just to give an example, right before the law passed, the number one criminal offense that women were in the ACI for, either pre-trial or after conviction, was for prostitution. That was the number one offense. So there certainly was not a problem of individuals not getting arrested for prostitution, even without changing the 1980 law. We were also troubled by a few other things that were occurring at the time leading up to the passage of the law and the city's attempt to address the problem of prostitution. One was an argument that some officials made that they were arresting the prostitutes, the alleged victims of the sex trafficking, as a tool to force their cooperation with police. That is to get them to give them information about who these traffickers were. We found that morally reprehensible as an extremely cruel policy. And it also was hard to understand why anybody believed that if this were happening, people wouldn't be afraid to do that. But That was a rationale given. And then related to that, unfortunately, another very disturbing aspect of the raids is that the city began collaborating with ICE, with immigration officials, and were contacting ICE when they had immigrants, women who were being charged with this offense, and a number of them were handed over to ICE and ended up, before being deported, often ended up being detained for months longer than they would have been if they'd actually been convicted of the crime of prostitution. But anyhow, notwithstanding all those concerns that the ACLU and a number of other organizations raised, the General Assembly did pass the law in 2009. But there are a few aspects of the law that I think largely went unnoticed, or at least are unnoticed now, that I think are worth mentioning. First, with all this talk of sex trafficking and the need to protect women, and that's why we're doing all this, the law as it passed actually provided very limited protection for women who were supposedly the victims of trafficking. What it did was it allowed them to establish an affirmative defense that they had been coerced into engaging in prostitution. That's a very heavy, and we would argue unfair burden to place on them. It's hard to do, as I mentioned. I think it's also hard, just as a practical matter, for anybody to snitch on these individuals who may have had their lives in their hand if they were in fact victims of trafficking. But the burden was on them, so that meant they would get arrested, they might get detained at the ACI, go to trial, and then at trial present as their defense that they shouldn't be convicted because they were victims of human trafficking. That's a very, very difficult road to ask anybody to go through, much less individuals who are allegedly victims of sex trafficking. A second thing that was added, that was included in the bill that became law, was a provision allowing for the seizure and forfeiture of any property that a woman owned that police claimed derived from the proceeds from prostitution. So as a result, under the very low burden that exists under the state's forfeiture laws, women could lose what little money or property they had as a result of an arrest and conviction, making, if these are people trying to turn their lives around, obviously making it much more difficult. And then a year later, the legislature amended another law that actually imposes special court fees specifically on individuals who plead or are convicted of prostitution offenses. It is a separate statute focused specifically on prostitution. So that was the 2009 law. So now I want to move forward and look at the past 5-6 years and see where we are, see what's happened. I think we all know every so often a prostitution street sting is conducted by a local law enforcement agency. The sting receives some media attention, but ultimately it has no lasting effect other than, in our view, embarrassing and penalizing consenting adults who've been engaged in sexual conduct for a fee. And by humiliating and giving arrest records to these individuals in the name of helping them, we think the law's major effect is just to make the lives of sex workers more difficult and dangerous. At about the same frequency, police will, raid massage parlors or a strip club like the Foxy Lady and claim to have acted in an effort to address the problem of sex trafficking. I don't want to suggest in any way that this never happens, but it does. But all too often, there is this conflation of sex trafficking with prostitution that is simply inexcusable, because that's not what ends up the result of these raids. It is the women who get charged, who get arrested, who get convicted, and there are no human sex traffickers to be found anywhere. I want to give just two examples because I think they highlight these points. In 2016, the Cranston Police Department conducted a sting operation, and they issued a news release announcing the results of it, that in its words, the police department's words, it was, quote, aimed at targeting human traffickers, specifically those victimizing juveniles. And according to their news release, no fewer than 8 law enforcement agencies were involved in the operation. According to news reports, however, the sting led to 1 arrest for trafficking, 1 arrest for pandering, 14 arrests of Johns for procuring sexual conduct, and 14 arrests for other people for engaging in prostitution. That was the net result of that sting. The second one I want to mention, which got a lot of public attention at the time, but I think it's important to remember or learn for the first time the facts behind it, and that was the raid and the closing of the Foxy Lady in 2018. And I want to highlight it because I think it exemplifies what is wrong with these laws and with their enforcement. Although the Foxy Lady had been providing adult entertainment in Providence for decades, it had never been called before the Providence Board of Licenses until a police sting there resulted in 3 women being charged with soliciting for prostitution. The board then took the extraordinary step of permanently revoking the Foxy Lady's entertainment and liquor licenses and throwing more than 200 people out of work just a week before Christmas. It did so after concluding, without any direct evidence, that club owners had, and I quote, created an environment for tolerating prostitution, close quote. And I want you to listen to that carefully. Note that the owners were not accused of promoting prostitution at the establishment. They weren't even accused of tolerating prostitution there. Their offense was that they had created an environment for tolerating prostitution, whatever that means. The unfairness is really compounded when you learn that the sting operation at the club was initiated because a female employee a few weeks earlier had been the victim of a sexual assault by a customer, and the club had sought the police department's help. But again, as a result of that, it was the women who bore the brunt of the punishment. These 3 women faced criminal charges. They had their names and their photos splashed across the media. And then dozens more were suddenly out of work and without a paycheck. Again, all of this is being done under the guise of protecting women. In one other respect, it actually gets worse. This permanent closure of the Foxy Lady, which was overturned administratively. But the true outrage was in comparing that permanent closure that the Board of Licenses issued with the penalties they'd imposed against other licensees who had much more serious trouble with the law. We did some checking. We went back a couple years and looked at the Board of Licenses actions in issuing punishment for other nightclubs that engaged in improper activities. And they included such things as a club where a bouncer had stabbed a patron, where a patron had shot a gun into the ceiling and the establishment deleted the video surveillance. And in both of those instances, the punishment was something like 2 weeks suspended license. So when you look at all the facts surrounding that particular incident, I think it just, as I said, I think it exemplifies some of the problems with trying to enforce these consensual laws. So as a result of all this, I don't think it should come as a surprise that the prostitution laws continue to be discriminatorily enforced. We filed an open records request with the City of Providence to obtain their prostitution arrest data for 2016 to 2019. And based on the information we got, they claim to have arrested 79 people on prostitution-related charges. 77 of them were for engaging in prostitution, only 2 of them for solicitation. 94% of the people arrested were women. We filed a similar request for Woonsocket, and it was similar. It was 89% women who were arrested. And we also found something extremely disturbing when we got the Woonsocket arrest reports. There were a handful of them where the police officer, in describing the incident leading to the arrest, and again, these are all stings, these are police officers looking for people to arrest. In a handful of them, the police officer described in their narrative of the arrest how the prostitute had asked them to squeeze or touch their breasts just to prove that they weren't a police officer. And the police officer obliged. And, to think that we are giving the police the power and authority to arrest people, and in order to do that, to engage in activity like that, I think should be absolutely condemned by everybody as another reason why this type of ban on consensual activity is simply completely inappropriate. Finally, we took a look at the uniform crime reports for Rhode Island because we also want to take a look at race issues. And we know that, throughout the criminal justice system, there are problems of race, and prostitution is no different. And you won't be surprised by the statistics we found. Out of all the arrests between 2015 and 2018 for engaging in prostitution, according to the uniform crime reports, almost 25% of the people arrested were black. In 2019, it was actually the only year we found where it was actually much lower, but if you combined it with the Asians who were charged with prostitution offenses, it was 31% of the people arrested in 2019 were either African American or Asian. So that is the history of prostitution in Rhode Island. I think it paints a pretty clear, consistent, and persistent picture, and one that we think really needs to be addressed. So I want to end with offering some of our suggestions for recommendations that we hope this commission will consider. I will note that if you look at the National ACLU report, they also have a number of much more, big picture recommendations that I encourage you to look at. Mine are much more specific. First, as politically infeasible as it might seem, we would urge for the decriminalization of prostitution. As an alternative, we would at least argue, based on the information I provided, based on the way the law has been implemented and enforced, that this commission consider recommending, at the very least, going back to the pre-2009 status quo, where truly private activity is not criminalized, and only the public display of conduct relating to prostitution is criminalized. That would be a significant step forward. While we recognize that either of those options may take a little time, will not occur this year, although I wouldn't underestimate the chair. I do want to just go through a list of smaller recommendations that we think also, in the meantime, should be considered. Number one, repeal the provisions that were added to the 2009 law that allow the police to subject a sex worker's property and money to forfeiture proceedings. And by the way, I will put this list of recommendations together in a document that I can share with you. Two, repeal the statute that requires those convicted of prostitution from paying extra court costs. Three, bar police from contacting immigration officials about women that they have arrested for prostitution. Four, remove the stigmatizing statutory requirement that any woman convicted of prostitution have an HIV test performed on them. Five, repeal a statute that imposes additional penalties for engaging in prostitution within 300 yards of a school. I don't think this activity is occurring at 11 o'clock in the morning. I'm not quite sure why a law like that is on the books, but it is. Six, once a woman has claimed she is a victim of coercion or trafficking, place the burden of proof on the police, not the woman, in order to obtain a conviction. Seven, enact legislation that's been introduced this year and last year by Representative Henrys to address, make very clear that police officers cannot engage in consensual sex with anybody who is in their direct custody. And finally, consider the use of non-incarceration penalties in the statute. Eliminate all the fees, court fees and costs that are imposed on individuals who do end up getting convicted or plead to the crime of prostitution while it continues to be a crime. So in conclusion, I just want to say in 2009, we believe the General Assembly made a terrible mistake in passing this harsh law. All it has done is, once again, make criminals out of people engaging in consensual sexual activity and put sex workers in more, not less danger. We think it is time for a fresh review of that law and the adverse consequences that have flowed from it, and we hope that the commission will take action to address these inequities. And with that, I will be glad to answer any questions.